Thank you, Mr. Chairman, and congratulations, Mr. Mathis, on your nomination. I want to start by adding my voice in support of Senator Blackburn and Senator Haggerty, and saying that I hope that the process has been followed in this nomination will never be the process again. But I also want to point out that this seems to be a more systemic issue in the sense that Senator Sullivan, who's not a member of this committee, as the chairman knows, Senator Sullivan, Alaska, has been unable to meet with any Ninth Circuit nominee who would be judging cases from his state for the entire past year. He has asked repeatedly to sit down with Ninth Circuit nominees. He's not a member of this committee, doesn't have the benefit of being able to ask questions here before we vote on them. He'd like to meet with them. And as of December, for months on end, he was unable to just ask questions of the nominees, and for that reason has been voting no on nominees he might otherwise be willing to support or at least to consider. And I just don't understand it. I don't understand why it's not possible, why this White House is denying senators the ability to meet with nominees, engaging in basic consultation. I don't get it. I guess it's just a no-holds-barred burn all before you strategy, but I have to say I think it's one that's going to backfire, and I think it's unfortunate. Mr. Mathis, that really doesn't have anything to do with you personally, so I'm sorry that you've had to sit through all of this because it's really not about you, but I agree with the chairman to the extent that I think these are important issues and I hope ones that we can get resolved. But let me ask you some questions about your own record. Let me ask you about a 2007 law review article. Were you in 2007? Had you graduated? Is that the year you graduated from law school?
That is the year.
So in this law review article, maybe you wrote it while you were in law school. I'm not sure about the timing, so maybe you remember. But in any event, I want to ask you about it. You argued there that the Supreme Court ought to create a freestanding actual innocence claim when it comes to federal habeas petitions, which, as I understand it, would allow a convicted defendant, to be able to relitigate his case at any time if he alleges that he has enough evidence to prove his innocence. Have I got that right? Am I rehearsing your argument right there?
Thank you for that question, Senator. That article I wrote while I was in law school. It was published in 2007. I think I was still in law school when it was published. And the case that I was writing about was House v. Bell, which is a case that originated in Tennessee, which is why it was of interest to me. And there was two issues that the Supreme Court took up in that particular case. I don't recall what the two issues were, but the court found in Mr. House's favor on one of the issues and therefore did not address the second issue.
And so do you continue to think when it comes to the federal habeas procedure and creating a freestanding actual innocence claim, do you think do you still advocate that position? Is that something that you think is still a good idea?
Senator, since I wrote that article, and I've been practicing, I haven't written academic articles since that time.
Probably wise.
I'm sorry.
I said probably wise, but
yeah,
go ahead.
I've litigated a number of cases and hadn't litigated issues related to the freestanding innocence issue. So I hadn't litigated that issue and haven't advocated for that particular claim since I was in law school.
Well, I ask because I have concerns about that. That would be a very significant departure in federal habeas law, which would create, I think, a very significant new set of challenges for prosecutors, for those trying to bring these folks to justice. And so it concerns me. But it sounds like this is not something that you've continued to advocate. Let me ask you in my time remaining here about some of these questions of experience that you've been getting. And you just said, I want to be sure I understand. You've argued 10 different appellate cases. Those are in federal court or state court? Or
those were in state court.
Uh-huh. And then how many circuit courts of appeals, federal courts of appeals, have you litigated in?
I've litigated in the Sixth Circuit.
Okay, just the Sixth Circuit? And you've not argued in the Sixth Circuit, is that right?
I have not argued in the Sixth Circuit.
How many appellate cases have you handled altogether in the Sixth or anywhere else, if you had to put a number on it?
23 to completion. I have one currently pending before the Sixth Circuit.
Okay. And to those who would say and have asked you about your record as an attorney, I know you've had a court kick back a filing because you didn't disclose what you're supposed to disclose. You mislabeled a brief for rehearing, had a court kick it back to you, and that, every attorney makes mistakes. But what would you say to those who say, well, his work sometimes a little sloppy, doesn't seem like there's a record here of courts sort of having issues with some of what the filings that he's given. What's your response to that?
Thank you, Senator, for that question. In any case that I handle, especially before appellate courts, I try to abide by the rules. You mentioned issues that were kicked back, one where I didn't do the PDF correctly, things of that nature. Those have happened. Of course, I correct those issues promptly, and none of those have prejudiced my clients, and there's been no issues with the breach that I filed.
Yeah, fair enough. Great. Thank you, Mr. Mathis. Thanks for being here. Thank you, Mr. Chairman.
Senator Hawley, if I could respond to a statement that you made earlier about Senator Sullivan, Republican senator from Alaska. He came to me and he believed that since Alaska is fairly unique in the Ninth Circuit, that he wanted to meet with the nominees for the Ninth Circuit. I checked into it, and there is a mixed record as to whether nominees make themselves available to individual senators. But I thought his was a legitimate and good faith effort to, he said, I've only got 2 or 3 cases relating to Alaska. I want to at least tell him what they are. Senator Murkowski agreed with him. I believed it was a good faith request, and I went to the White House, and he did meet with 2 Ninth Circuit nominees as a result of it. I'll offer the same support to any member of the committee who is not in the interest of delaying anything, but in genuine interest of knowing where they stand on cases that are relevant to their states.
Thank you for that, Mr. Chairman. I'm glad you intervened in that respect. And I think your last point is an important one, that Senator Sullivan wasn't trying to delay anything, but and he's not a member of the committee. He didn't have the ability to ask questions. But I just regret, make my point again, I regret that you might remember that Senator Sullivan went to the floor and blocked a number of nominees and voted no. And he had to do all of that in order to get the attention of the White House. And I thank you for your good offices, but it really shouldn't come to that. And I see this situation as similar. That Senator Blackburn and Senator Hagerty have had to say, listen, this is really wrong, and point out that they haven't been afforded basic consultation rights, and that really shouldn't be necessary. But thank you for your good offices in that circumstance.
You're welcome. I believe Senator Padilla is waiting to join us virtually. Senator, are you there?